justice process overview is the administrative structure. 1. Administrative diversity. Throughout the Supreme Court opinions reprinted in this volume, you will find references of the generic nature to police, prosecutor, defense counsel, and courts. These are the four groups primarily responsible for the administration of the criminal justice process. Police officers, prosecutors, and judges will hold official positions within governmental units and in describing the procedural history of the case. The court will often refer to the position held by the particular actor in the particular governmental unit. Example, that the arresting officer was a detective in the municipal police department. Rarely, however, will the court go beyond that brief designation. Opinions presume familiarity with the institutional structures of the wide variety of governmental agencies that have been responsible for performing the administrative functions. Of police, prosecutor, and courts. So too as the defense counsel. The opinions assume familiarity with the institutional arrangements that provide counsel for defendants. And this section briefly describes those institutional structures. It concentrates largely on the state systems, although significant distinctions in the administrative structure of the federal system are briefly described in the accompanying footnotes. 2. Police agencies. Of the four major groups involved in the administration of the state criminal justice systems, the police group is the largest and has the most diverse range of functions and most complex organizational structure. Fragmentation. A key feature of the organizational structure of police agencies is the fragmentation in the allocation of police authority. Indeed, the 50 state criminal justice systems together have almost 18,000 different agencies that can be classified as police agencies. In that, one, they have among their primary responsibility is the enforcement of the state criminal law, and 2, at least some of their employees have been given this special criminal justice enforcement powers that distinguish police officers from other personnel involved in enforcement, typically full arrest powers and weapon carrying authority. The vast majority of these governmental agencies are units of local governments, example, municipal police departments or county sheriff's offices. Although there are over 1,000 agencies that are part of special geographical units, example, a park police department or a college campus department or a state government. Apart from Hawaii, no state has less than 40 different police agencies, and most have at least 250 different agencies. The fragmentation of police authority invariably produces substantial variation in the exercise of that authority from one community to another within a single state. A dominant characteristic of state law regulating police conduct is in recognition of broad areas of police discretion. Typically, where the law allows the recognition of broad area, where the law allows the police to take a particular action only if certain prerequisites are met, it does mandate that such action be taken simply because those prerequisites exist. An arresting officer, for example, has the authority to search the pockets of the arresting person, but also has the discretion to choose not to do so. In many instances, the law gives the officer the discretion to either act or take no action, but in others, it also grants discretion to choose between the alternative paths of action where, for example, where probable cause exists, either taking the person into custody via an arrest or simply issuing a summons directing the person to appear in court at some later date, where state law allows for such discretionary decision making. Police agencies often seek to fill that regulatory void in one fashion or another. They seek to channel the exercise of discretion by their individual officers. Many do so informally through an organizational ethos that utilizes a variety of devices. Example, training programs, socialization, and incentives to influence the exercise of authority in individual officers. Others adopt written guidelines that are enforced internally through employment sanctions. In some instances, municipal governments have adopted ordinances that require officers in municipal police departments to exercise or not exercise discretionary authority in a particular way. The end result is that policies on the exercise of discretion differ from one community to another, and sometimes within a community when more than one agency is exercising police authority in that community. The differences are often so substantial that commentators will describe a particular state as having many different criminal justice systems in practice, although the law on the books seemingly creates a single system. Agency responsibilities. Police agencies within the state criminal justice systems vary in their responsibilities. Some agencies, primarily at the state level, are largely limited in their responsibilities to the enforcement of the state's entire criminal code or a portion of that code. Their agents are involved almost exclusively in investigating possible violations, collecting evidence, and apprehending offenders, often acting in conjunction with other police agencies. However, the vast majority of police agencies in the state system are general purpose agencies, which gives them numerous additional responsibilities. Municipal police departments, for example, also are responsible for providing basic social services, example, providing emergency aid, maintenance of public order, like a traffic control, and efforts directed at the prevention of crime, for example, providing a physical presence through patrol activities. Sheriff's departments commonly add two other functions: a corrections function in the administration of jails, and a court operations function that includes serving civil process and providing court security. The more diverse responsibilities of the general purpose agencies may impact the various ways that the agency's approach to its law enforcement function. Um, Initially, the general purpose agency must take account of the fact that with its resources spread over a broad range of responsibilities, a large portion of its personnel, including in particular its largest segment, patrol officers, who spend the bulk of their time on order maintenance and service function, will be relatively inexperienced in the investigation of serious crime. Second, the diverse responsibilities of the agency may lead it to adopt a somewhat different focus in the selection of officers, as the qualities needed in criminal investigation are often viewed as quite different from the qualities that lead officers to excel in performing other police roles. Third, the diverse responsibilities may lead the general purpose agency to adopt a flexible and informal style and community interactions that will work well in performing other functions but make officers less likely to adhere closely to the formal legalistic requirements that apply to police investigations. Um, to police investigations. Agency size. Another important variable among police agencies is the agency size. Sharp differences in agency size exist in almost every state, while substantial authority of the local agencies has fewer than 25 officers. Over one third of all officers of local agencies are employed by the 50 departments with 1,000 or more officers. Agency size, particularly as the small agencies, bear substantial correlation to differences in the organizational structure, resources, and patrol and enforcement policies of police agencies. Although the community served, for example, whether rural or suburban, adds an important further layer of distinction for small agencies. Smaller departments do not have the specialized units commonly found in larger departments, for example, vice burglary, um, although many do utilize the oldest of all special groupings, a separate detective unit. Smaller departments also are far less likely to utilize proactive investigative procedures, example, undercover agents, decoys, or tactical patrol techniques, i.e., the aggressive pattern of stopping and incidental frisks and searches that are associated with police crackdowns, because small police agencies are more likely to rely on the assistance of a generalized state agency for forensic investigations. They similarly tend to make less use of forensics than larger agencies with internal forensic units. Having less financial support, smaller agencies also are less likely to take advantage of advanced technology, for example, in-field computers. Um, third, prosecutors. All state systems separate prosecution agencies from police agencies. None simulate the federal structure, which places several of the major federal police agencies and all federal prosecutors in the same governmental department, justice, under the executive authority of a single official, the Attorney General. Thus, county prosecutors, although commonly described as chief law enforcement officer of the county, actually have no direct regulatory authority over the various police agencies operating in the county. Um, of course, the prosecutor does have the authority to refuse to proceed in a case presented by the police, and that power base may be utilized to convince the police of or to discontinue practices that the prosecutor views are contrary to the public interest. That authority, however, hardly puts the prosecutor in a position comparable to a supervisory official. Police are not always interested in obtaining a prosecution, and they are aware that if they produce evidence adequately to gain a trial, conviction, or plea bargain as to a serious offender, the prosecutor will be under considerable pressure to go forward with the prosecution, even though the police did not proceed as the prosecutor would have preferred. In many respects, the same factors that produce organizational diversity among police agencies also produce organizational diversity among prosecution agencies. Here, differences in agency responsibility are not quite so different, although the distinction between agencies that have responsibility for only for criminal law enforcement, agencies that also have civil litigation responsibilities can occasionally contribute to the adoption of different positions on a limited range of criminal enforcement issues. On the other hand, the fragmentation of authority and differences in agency size, as in the case of police, police agencies contribute substantially to diversity in the exercise of prosecutorial functions. Prosecutorial functions. Fragmentation in 3 states, Alaska, Delaware, and Rhode Island. The Attorney General's office is the sole prosecution agency, although the staff may be assigned in part to local offices. In the remaining states, the primary responsibility for prosecutions is vested in the local prosecutors, who are local government officials, typically for individual counties or multiple county jurisdictional districts. These prosecutors, having a variety of titles including district attorney, state attorney, and county prosecutor, generally are elected officials who ran for office as political party nominees. In some states, they are the only prosecuting officials. That's not right. In some states, they are, okay, that is right. In others, the Attorney General also have separate prosecutorial authority, but that authority either will be limited to a narrow band of offenses or will be exercised only under special circumstances, for example, where the crime has a statewide impact. In some states, however, the city or county attorney has the authority to prosecute ordinance violations that carry criminal penalties. See FN.3 Super. The 47 states relying on local prosecutors have over 2,300 prosecutorial districts. Several states have over 100 districts, and even smaller states. Prosecutors are granted broad discretion in exercising their authority, particularly as to the decision to prosecute. See step 4 at page 18 infra, and in plea negotiations, see step 14 at page 25 infra. Not surprisingly, different prosecutor offices in the same state often will adopt quite different policies in exercising that discretion. Indeed, the fragmentation of the responsibility of prosecution is designed to produce such variation as its purpose in large part is to ensure responsiveness to the particular values of the local community that elected the prosecutor. Size. Prosecutors' offices do not vary in size quite so dramatically as police departments, but differences are substantial and do have a bearing on organizational policies. While offices in large urban districts commonly have over 100 assistant prosecutors, over half of all prosecutors' offices have no more than 3 assistant prosecutors. Prosecutors in smaller offices have limited resources and a limited range of experience, which impacts their approach to prosecuting such offenses as multi-party conspiracies or complex white-collar crime. These offices typically do not have access to the array of non-lawyer support personnel common in large offices, for example, victim advocates, and that may produce differences in their approach as to still other aspects of the docket. Small offices also tend to adopt a more flexible decision-making process, allowing for ad hoc variations. Large offices, in contrast, often adopt fairly specific internal standards governing such basic decisions as the use of diversion, see FN.14 infra and often create special programs for special offenses, example, sex offenses, or offenders, example, implementation of a clearly defined mission, example, obtaining the longest possible incarceration. For defense counsel. Defense counsel in criminal cases may be privately retained counsel or counsel provided by the state for indigent defendants. A study of prosecutions in the 75 largest counties determined that 82% of state felony defendants were found indigent and received counsel provided by the state, while the percentage may be somewhat lower in some states. State funded counsel clearly dominate representation in felony cases in all jurisdictions. In misdemeanor cases, the percentage of retained custody probably is higher because counsel is more readily afforded, but state funded counsel also will represent a substantial portion of all misdemeanor defendants. Um, retained counsel. Retained counsel in felony cases represent various segments of the private law bar. Okay, of the private bar. They include general practitioners, particularly in small communities who handle all types of litigation, big city courthouse regulars, primarily solo practitioners who handle heavy criminal caseloads, basically involving garden variety charges against clients of lower economic status, corporate lawyers who handle white collar cases, and the highly publicized litigators who represent affluent defendants in drug cases, conspiracy cases, and occasional homicide cases. Appointment systems, where the state provides counsel, various delivery systems are used. The most common are appointment of an individual assigned counsel to appointment of an entity that has contracted to represent indigent defendants on a bulk basis known as a contract attorney system. And third, automatic representation by a public defender's agency. Many states utilize local appointment systems it prefers, where a contract attorney or public defender system is used. It will be supplemented by individual appointments where the contract or defender office's representation of one defendant creates a potential conflict of interest in the representation of other defendants. The appointment process and systems relying on individual assigned counsel will vary. In some judicial districts, the appointment will be made by the court, with the judge either exercising discretion in choice or automatically rotating appointments among a panel of approved authorities seeking appointments. In others, the court is removed from the appointment process with a rotation system administered by an independent authority or agency that approves the panel. Contract systems may utilize a variety of different contract agencies, but such agencies will most often will be a private law firm for a nonprofit entity sponsored by the local bar association or the legal aid society. The contract may cover all cases or a specific number of cases and may be based on a flat fee or an hourly fee with caps, the typical fee system for appointed counsel. Public defender agencies will be either statewide agencies with local offices or local government agencies. Their attorneys are government employees engaged full time in representing indigent criminal defendants in larger offices. Other personnel include investigators and social workers. Judges. Basically, 3 levels of judges are involved in the administration of the criminal justice process. At the first level are the courts of limited jurisdiction. These courts are known by a variety of different titles, including justice of the peace courts, police courts, and county courts, because they perform many of the same functions that were assigned to magistrates in the English common law system. These courts often are described as magistrate courts. The second level consists of trial courts of general jurisdiction. These courts have a variety of different titles, including district court, court of common pleas, superior court, and the circuit court, but often are described as a group as felony trial courts or general trial courts. Finally, the third tier consists of the state appellate courts. Since these courts basically have a single function, appellate review, which is discussed in Section 3, see Step 17, page 27, infra, and a fairly standard structure, also discussed there. Our discussions here will focus on the magistrate courts and the felony trial courts. Magistrate courts. The trial jurisdiction of magistrate courts will not extend beyond misdemeanors, and some states will exclude from that jurisdiction more serious misdemeanors. These courts, however, also have considerable additional authority that extends to offenses, example, felonies that are not within their trial jurisdiction. The authority begins with matters that can occur even before the defendant is arrested, such as the issuance of arrest warrants and search warrants. Once arrested, the defendant must be brought to court for a first appearance, which also is known as initial presentment, arraignment on the complaint, or preliminary arraignment. Step 7, page 21, infra. Although this proceeding can occur before any judge, traditionally is the magistrate's responsibility. The magistrate's function here includes determining the conditions for pretrial release and if the person is eligible for court-appointed counsel, ensuring that steps have been taken to provide appointed counsel. If the charge is a felony and a preliminary hearing is held, see Step 8, page 29, infra. The magistrate also will conduct that proceeding. In most states, the magistrate judge sits on a court that is separate from the trial court, but in some states, the magistrate court is part of a consolidated trial court. Example, the magistrate court is in effect a division of the trial court. In cases where the magistrate court is separate, there may be several different types of magistrate courts, including some designed as courts not of record. Such courts are designed to provide a swift, inexpensive, and convenient mode of disposition of minor criminal charges with a more formal backdrop, just adjudication available to the defendant through a trial de novo, example, a new trial for on both facts and law before the trial court of public or general jurisdiction. Judges of magistrate courts not of record frequently are part-time lay judges. In contrast to their exercise of trial jurisdiction, magistrates in a court not of record will have the same authority with respect to preliminary proceedings in both misdemeanor and felony cases. For example, on issuance of arrest warrants as magistrates in each or in courts of record. Felony trial courts. These courts will be part of the statewide system, but that will be divided into judicial districts and consist of a single county or several contiguous counties. In either respect, felony trial courts are similar in their authority from one to another. The primary distinction is that in some states their trial authority will include a potential of a misdemeanor docket. Example, all misdemeanors punishable by incarceration of more than 6 months. The primary organizational distinction relates to the size of the court. Even where multi-county districts are utilized, there is likely to be a number of courts that have 3 or fewer judges. On the other side, roughly half of all state felony trial judges at the districts with 15 or more. On the other side, roughly half of all state felony trial judges sit in districts with 15 or more judges. Larger districts often use a structure that emphasizes specialization. Many utilize separate criminal and civil divisions. The types of cases, i.e., narcotics, Some multi-judge courts assign judges to specialized calendars dealing with such matters as pretrial motions, grand jury items, and the acceptance of pleas negotiated prior to placing a case on the trial calendar. Very often, judges are assigned to particular divisions in anticipation that they will often or exercise their discretion in a particular fashion that is deemed in the best interest of the court as whole, typically reflecting an interest in moving the docket and maintaining a degree of uniformity in the treatment of similar administrative decisions.